both of our panelists for their key takeaways or their final thoughts. Andrew, you led us off this afternoon. Perhaps you want to be the first to close us out with a few of your final thoughts.
Sure, happy to do so. Thanks. Yeah, just to come back to one point and just sort of reemphasize it, I do think that we're in an environment now, particularly with COVID pandemic and plaintiffs trying to take advantage of that situation in litigation. We're seeing an increased number of multi-patent suits. ODP should be among the arrows in your quiver as you prepare your defenses. And if you are on the plaintiff side, again, it needs to be something that you are factoring into your diligence process. And just given the availability of terminal disclaimer to cure, but only as to a patent that has not yet expired, there needs to be careful strategic considerations of when to press the defense and when to seek adjudication of it. Also, so that you can potentially, as a defendant, lay traps during depositions of experts or during claim construction to try to enhance your chances of winning. So it's an important defense that takes, I think, a lot of careful strategy to deploy effectively, and those should be part of your litigation arsenal.
Thank you so much. And Jennifer, a couple of final thoughts from yourself to close us out this afternoon.
Sure. I hope you have gotten a better appreciation from my talk today about how obviousness-type double patenting is handled in Canada. It's interpreted very broadly as applying to claims related to the same invention, and it's applied very strictly to having the first patent to issue bar the patenting, the issuance of any other patent that has claims that are considered to be either not novel or obvious over the claims of the first patent. I've tried to provide you with some examples too in our case law of situations where claims have been refused or invalidated for same invention, double patenting, even when the claims contain an extra feature over the claims of the first to issue patent, or are directed to a different category of invention than the claims granted in the first to issue patent. And the consequence of this is that I want to give you the message that if you or your client is not happy with a claim set for any reason, we really strongly recommend that you try to address this while the application or applications are still pending, and that you have a better understanding of how you can go about this in Canadian practice to get a really good result and a patent that you'll be able to enforce. Thank you.